Good morning, everybody, and welcome. This morning, we're privileged to be joined by the Privacy Commissioner, John Edwards. John will be addressing the Privacy Act 2020 and what this means for you. Welcome and thank you again for joining us, John. For those of you that I haven't had the opportunity to meet as yet, my name is Jill Stewart. I'm the CEO of the IAB New Zealand. We're pleased you could all join us for this morning's webinar, and we'll be focusing on the new Privacy Act, which comes into effect on the 1st of December 2020. The Act introduces a number of new privacy protections and obligations, including mandatory breach notifications, access directions and compliance notices. This morning, the Privacy Commissioner will be explaining these changes and outline what they will mean for businesses and organisations in practice. John's presentation will be followed by a Q&A session, which will be hosted by IAB New Zealand Chair and Managing Director of MI9 New Zealand, Rhys Heron. Welcome and thank you for conducting this session, Rhys. Some of you will be aware that the IAB held a data and privacy event recently. John was our keynote speaker. We received considerable feedback during the session and didn't have the opportunity to cover off the questions we received. In this morning's Q&A session, Rhys will be addressing some of these questions to the Privacy Commission, as well as taking your questions from the webinar. So please feel free to ask questions through the Q&A box on Zoom, and we'll do our best to get to each of these today. Again, thank you for joining us, and now over to the Privacy Commissioner for his presentation. Thank you, John.
Kia ora koutou katoa. Thanks everyone for tuning in. If I can just do a check, everyone can hear me and see me. Please let us know in the chat or Q&A if there's any problems with the broadcast. We have one chat. It's a slightly odd format, but we're all getting used to it now, of course. I've come to talk to you about the Privacy Act in 2020. Now, I've been working in this area for a long time, 30 years, more or less. And in that time, every couple of months or couple of years, you know, odd intervals, I see these headlines, privacy is dead. Often those are uttered or created by people in whose interest it is for that to be so. Our privacy is not dead, privacy endures, and anyone who thinks privacy is dead today hasn't been paying attention to the political scene in New Zealand over the last week. It is privacy that ended the careers of at least 3 prominent politicians in this last week. So it's worthy to reflect on that. The Privacy Bill passed a couple of weeks ago, and we now have a Privacy Act 2020. It will come into force on the 1st of December. I want to tell you the new initiatives that are in that legislation, what has changed from the Privacy Act 1993. But I think it would be wise for me, before I do that, to tell you what is in the Privacy Act 1993, just in case you haven't read it recently. I can't take a show of hands as we did in the in-person session in Auckland and ask how many people have read the Privacy Act or have read at least the Information Privacy Principles. But I do think it's best if we just sort of have a little recap and understand the fundamental principles of the Privacy Act, and then I'll tell you what's changed in the Privacy Act 2020. At the heart of the Privacy Act are 2 concepts that we need to hold in our head. One is the term agency. Agencies are the entities obliged to comply with the information privacy principles. And an agency is a person or body of people, whether corporate or unincorporate. And what that means is that it's a sports club. Right? It's a scout troop. It's an insurance company. It's a church. It's your business. It's a law firm. It's all the different branches of government. And, you know, when you start thinking across the economy of hospitals and chemists and podiatrists and builders and mechanics and moteliers, you start to get a sense of the breadth of application of this law. The other key principle is that it is concerned, the Privacy Act is concerned with personal information. And that's a term that's defined very widely. Personal information means information about an identifiable individual. It doesn't mean private information. It doesn't mean sensitive information. All it is it has to be information which is about an identifiable individual. Now you put those two components together and you have a law that reaches into almost every aspect of human activity. And the only way a law can cope with that diversity of application is by being a fairly high-level principle-based approach, which our Privacy Act is. Most privacy acts around the world, or data protection acts as they're called in many jurisdictions, are based on principles set down by the OECD in 1980. Now, those principles are described in our Privacy Act as information privacy principles, and they follow the life cycle of personal information. Principles 1 to 4, for example, talk about what information you can collect and how and from whom, and what your obligations are when you do that. Principle 5 says you've got to keep that information secure. How secure? Well, that depends. Depends how sensitive it is, it depends what you need it for, and how you use it. Principle 6 says everybody has a right to access their own information. So if you're an employee or a customer at a bank, you can go to your employer or your bank and say, give me all the information you have about me. Now you're sitting there in your chair in at least two capacities. You are individuals who enjoy rights under this legislation, and you are agencies that have responsibilities. So if you have staff, then you need to be ready for them to access their personal information. If you have customers, they may, for example, exercise that right of access. Principle 7 says everybody has a right to correct personal information once they've accessed it, if they believe that it's wrong or incomplete or not up to date or irrelevant or misleading. And Principle 8 says before you use personal information, you've got to take reasonable steps to ensure that it's complete, relevant, up to date, not misleading. Principle 9 says don't hold personal information for longer than you need it. That's a really interesting one that's come to the fore in relation to COVID and contact tracing registers, for example. How long should you be keeping that? Well, the clinically indicated period means maybe only about 30 days. And 10 and 11 say you should only use or disclose personal information for the purposes for which you've obtained it, or if a limited number of exceptions apply. So that's the core of the Privacy Act, these information privacy principles. The Law Commission examined how the Privacy Act works, and they took some years over it. And in 2011, they produced a report, and they said, these fundamentals work pretty well. This principle-based approach with its application right across the economy seems sound. So we'll keep that, but they did recommend a few tweaks. Their bill, the government accepted the recommendations of the Law Commission in 2014 and started a process of drafting. It got stalled and there was a new government that picked that work up, put it into the House in March 2018, and we finally had that passed just a couple of weeks ago. So the key sort of policy changes in that law, first, there will be a new obligation to report privacy breaches that could cause some serious harm. Now, I'll show you some examples of those in a couple of slides, but what we've seen over the last few years is the potential for organizations to get their security settings wrong, to not take privacy seriously, and for that to cause leakages of personal information, which can cause quite significant harm to individuals. You know, we saw Yahoo, for example, hacked to the tune of about 1 billion email account details. Now, breach notification means that when you experience this, you have to tell the individuals concerned, and you have to tell my office. And that's because you've failed in your duty to protect the information. You need to put people back in the position to take control themselves and to protect themselves. In the case of that Yahoo breach, for example, it was years before they fessed up to that. And in that time, all that personal information, that identity information, that password information is available on the dark web. So this has been the most controversial aspect of the new law, or perhaps not controversial, perhaps uncertain. The mandatory part of mandatory privacy breach notification means that it will be an offence if you experience a breach that should have been reported and you don't report it. However, there is some uncertainty about what that threshold is. How do you know if a breach could cause serious harm? If you are sending an email to your play centre colleagues and you describe a child's gluten-free status and you put everybody's email address in the CC field rather than the BCC field, have you committed a privacy breach? Well, that one in particular probably isn't going to reach the threshold of causing serious harm. How do you make this decision? Well, the legislation has put some criteria in there. So take into account, for example, how sensitive is the information that you've lost control of? How widely has it been distributed? How successful have your attempts to retrieve it and get it back and keep it safe have been? How secure was it in the format that it was lost? For example, you realize when you get home that the USB stick full of your customer information has fallen out of your pocket on the bus. Was that encrypted or password protected in some way? So that's going to be quite a significant new obligation on industry. We're preparing a whole lot of materials and a reporting website. We're preparing a decision-making tool to help you understand whether the experience that you've had meets that threshold of serious harm. And those will be available. We've also got training materials that I'll talk to you about in a moment. The next clutch of new initiatives relate to the enforcement of the Privacy Act. Many of you will know that I went into bat in submissions to Select Committee and to the Minister of Justice and said, I need the kind of powers that my colleagues in other jurisdictions have. In Europe, a privacy commissioner can issue fines of up to 4% of the global turnover of a company. That sort of gets the attention of industry and bumps privacy up the agenda on the Risk and Assurance Committee. Consumer privacy is administered in the US by the Federal Trade Commission. They last year issued a fine of $5 billion to Facebook. And again, quite a significant attention-grabbing kind of number. Although on the day they did that, Facebook's shares skyrocketed. So I didn't succeed in my quest to have that level of enforcement. The government instead stuck with the 2011 recommendation of the Law Commission to give me the power to issue compliance notices. So I will be able now to identify non-compliant behavior, investigate it, issue a notice which requires the agency to come into compliance, and then if they don't, to enforce that notice in the Human Rights Review Tribunal, and failure to comply with that will lead to a fine of $10,000. So it's a slightly protracted process, and it doesn't have an ending with the same kind of accounting significance as my other colleagues do, but it will be a significant addition to the enforcement power. Let me just linger on that for a moment, because it's not widely understood how unenforceable, in a sense, the Privacy Act has been. For most of the last 26 years, enforcement has relied on individual complaints. Now, you can't bring a complaint to my office unless you can identify that an agency has breached one of the information privacy principles, and that breach has resulted in some actual damage or loss or significant injury to feelings or significant humiliation. So last week, for example, when we were talking about the movement of personal information about COVID-19 cases, people were talking about, is it illegal? Is it a breach of the Privacy Act? You know, is there criminality involved? And the answer is, well, for the MP involved, MPs are not subject to the Privacy Act. For others, it's only enforceable in reality if you are the person who suffered and you did suffer some significant harm. So this is going to change with compliance notices. I'll be able to go out there and check on things. You know, if I find myself in a pub and confronted with a COVID-19 contact tracing register on the bar, which gives me no information about how they're going to use the information, which doesn't take adequate care to secure the information so I can get to see everybody who's on the premise at that moment because they've all signed in before me. I can issue a compliance notice and require that to be changed without anyone having to make a complaint or without reaching that threshold of harm. So you know, it's not a wet bus ticket, but it is a significant change in the way in which the law will be able to be enforced, and it will affect the way that we run our office. And I'll talk to you about that in a moment. There are new criminal offences in the Privacy Act. It will be a criminal offence to impersonate someone with the intention of obtaining their personal information. It will also be a criminal offence if, when somebody asks you for their personal information, you destroy it rather than dealing with it in accordance with the Act or providing it to them. Those are criminal offences, punishable by fines of up to $10,000. We get about 800 or 900 complaints in my office every year. About half of those are access complaints. That is, someone has asked for their information and the agency has failed to give it to them or has not responded or something like that. I'll have a new tool of issuing binding decisions, which means that I can make legally binding decisions, which you may be surprised to know I can't do at the moment, except in very limited circumstances. The law has been clarified and changed in a couple of respects in respect of the territoriality. In law, there is a presumption that you only are bound by a law in the territory that you are in. We've now, our economy is significantly affected by organisations which operate here in a commercial sense, but have no legal or physical presence here. The Privacy Act 2020 will explicitly apply to an organisation that is doing business here, whether or not its servers are located here, its corporate office is located here, or even if it has any staff or physical presence here. And an example of that you may be aware of is the Commerce Act, which applies, you know, the new part of the Privacy Act is sort of modelled on. And the Commerce Commission last year took action against a company called Viagogo, which sells made-up tickets to events and rips people off. And they are based in Switzerland. They're accessible by New Zealand customers. They offer tickets to events that are happening in New Zealand, and they are making money out of New Zealanders. So the Commerce Commission said, all right, even though you're not here, you're in Switzerland, you're subject to the Commerce Act and the Fair Trading Act, and we're going to prosecute you. The other aspect of territoriality, which you'll need to be conscious of, and I've got a couple of questions from our last session on, I think, is the movement of personal information from New Zealand to other agencies outside the jurisdiction. You'll need to take some steps to satisfy yourself that the information is adequately protected. And that's either by going to a place that has a comparable level of privacy protection, or that the information is protected by contractual clauses. So if, for example, you're a travel agency and you are partnering with an adventure tourism business in Papua New Guinea, you'll be sending New Zealanders' personal information to Papua New Guinea. You'll need to make some inquiries about the data protection situation there. I'm pretty sure it's not great. And if it's not, then you'll need to either get the very explicit consent of every person whose personal information you send to that other agency, or you'll have a contract with that agency that includes clauses that provide a similar level of protection. And we'll be providing some of those clauses. We've just let a contract to a major law firm to draft those. Those will be available from our website. We also have a role in advising on which jurisdictions will meet that test of comparable protection. So that's the strengthening cross-border protections aspect. So my priorities for 2020, well, I mean, everybody's priorities have been completely upended, haven't they? And like you, I have had to change my business to meet the challenges of COVID-19. And they have been significant. We've seen a lot of personal information issues arising out of contact tracing apps, the kind of assistance that the government has offered and the information needs of that. We saw the issues last week with the leaking of COVID-19 diagnostic information. So that's really upended our work program. But through that, we've continued to prepare for bringing into force the Privacy Act 2020. That's really been a significant focus for me. We've got to educate the public. That's part of what this seminar is about. We've got to make the compliance easy. But we're also taking the opportunity to reconsider our regulatory approach in a process that we're calling Privacy 2.0. Now, I could have taken those half a dozen new policy initiatives from the Privacy Act and just bolted it onto the way that we do our business already. But our existing way of working in our regulatory model and our business processes are really founded in a 1980s model, which we adopted when the Privacy Act 1993 came in from the Ombudsman. And I don't think that's sustainable anymore. I'm not sure that it's the most efficient way for me to spend the money that is allocated to me by the Crown. So we're looking at how we do what we do and trying to make it more efficient, make it more customer focused and more accessible. I'm also interested in this idea of regulatory convergence. You know, we have a problem in the privacy and data protection world, which I've described as the "they are one and we are many" phenomenon. You know, there is, in this digital age, the business model of there can be only one. One ride-sharing app, one social media, one video sharing platform, you know, one accommodation booking service or sharing service. But there are many, many different regulators. There are over 100 privacy commissioners. So that's something that we need to do, is to connect more closely with our international colleagues. But I think also those big data industries play regulators off against each other to a certain extent. So I think it's really important that I join with my domestic colleagues as well, and that we leverage each other's jurisdictions. So, for example, the Commerce Commission has a key role to play in fair information practices, in antitrust kind of behaviours. And we've seen in Australia, for example, the ACCC take on Google for its location tracking. We see the Federal Trade Commission in the US working actively in this area. So I think there is scope to be a bit more connected in the domestic regulatory context as well, which I'll be pursuing. So we see lots of privacy breaches, and we've, for the last few years, collected those on a voluntary basis. People have reported to us where things have gone wrong. They don't have to, but they have, and that's been helpful. So we can share that information. We're expecting that probably, if we follow the Australian experience, we'll see a bump in breach notifications of about a factor of 7. So about 7 times as many as we receiving at the moment. Email errors are a very common way for people to lose control of personal information. Employee browsing is a real risk. You need to think about that in your business. If you don't know what employee browsing is, it's where a trusted employee who has access to the system for legitimate business reasons uses it for illegitimate reasons or their own personal reasons, checking up the credit score of their daughter's new boyfriend or that kind of thing. And you know, I think if you want to do one thing to prepare for the new privacy world, it's instill a culture of respect for personal information in your organization. Get everyone to do one of our training courses, which I'll come to in a moment. But another is to just do spot audits. If you've got an access log to information in your customer systems, just take 5 or 10 access examples every month and go and ask the person why they were looking at that. Now, they may not remember. They'll say, you know, I look at hundreds a day for my job. How do you think I can remember that? Fine, doesn't matter. What matters is that they know that they'll be asked and that they may have to justify an access attempt. And that'll make them think twice about inappropriate access. And we see website errors, and I'll talk to you a little bit about a couple of those. So preparing for the new Privacy Act, it's really time for a recheck. You need to go and tell the boss or the chairman or the Risk and Audit Committee that we've got a one-off opportunity to prepare ourselves in the way that we did for health and safety changes a few years ago. And it's the time to get their attention and get a bit of investment. You need to have a privacy officer. If you haven't, you've been in breach of the Privacy Act for 26 years. That's not new, but you know, it's really important to now start to take this stuff seriously. If you've got a lot of, you know, personal information, put together a breach response plan. How, you know, what are you going to do if things go wrong? Particularly if you're in an organization that has a lot of very sensitive personal information. And check up on your overseas partnerships. Update your privacy statement. That's a good opportunity to do that. Everybody needs one. When you collect personal information from an individual, you've got to tell them what you're going to do with it. Now, we've developed a tool for that. We call it the Privomatic. You can jump onto our website, which is privacy.org.nz, and you'll see there a tool which in 5 minutes will give you a pretty serviceable privacy statement that you can put on your brochures or your website, or you know, put on a poster in a customer service area. These privacy breaches, when they happen, can be very uncomfortable. I mean, look at what's happened to the National Party, right? We've had an MP, a former president of the party, and now the leader all go over privacy breaches. These guys, the PHO, had a very uncomfortable time when they realized that some malware had been placed onto their server, which could have compromised the security of up to 1 million patients. When these things happen, you've really got to get in and try and understand what happened, who's been affected, what information was exfiltrated, if any, and what you need to do in order to allow people to protect themselves. So having a breach plan, for example, we've talked about all those things, and maybe, you know, think about investing in some penetration testing. What sort of website systems are you using? How old are they? There was a really interesting case also last year that I think was called Tuia 250, the commemoration of Cook's visit to New Zealand. Now, that was run by the Ministry of Culture and Heritage. And when they set up that a website to service that commemoration, somebody put, you know, just built them something, right, from WordPress or something. And that was fine, because basically at that initial point, the website was functioning as a bulletin board. just a pushing out of information about events. At some point, somebody had the bright idea that we could have a competition, and the prize would be you get to paddle in a waka out to meet the replica Endeavour or something. And to run a competition, you need to elicit information. And some 300 people, so somebody just added in a plugin to the website and offered up this competition to the public. 300 people uploaded identity documents, including passports, driver's licenses, firearms licenses even, and a whole lot of other information to the website, not knowing that that website was completely insecure. I mean, not just by accident, but by design. You know, those documents were being uploaded to a public-facing platform. So anyone who searched one of those names would go directly to those identity documents. And the ministry didn't notice this for some months. And it was only when the father of one of the applicants got in touch with the ministry and said, look, someone's been trying to use my son's driver's license to obtain credit, and the only place he's used it has been this website. So check on that sort of stuff, right? Just do a bit of an audit or a check on your website. We had another one just recently, a complaint that came across my desk. A person applied for a job and didn't get it. Months later, they Googled themselves and they found their job application uploaded again to a public-facing website. So there's no excuse for that kind of stuff these days. You've got to ask these basic questions about data security. We will continue to have challenges with contact tracing and machine learning and AI. I've seen facial recognition start to really become a significant issue internationally. And again, you know, the hegemony of the increasingly powerful tech companies. And we're seeing deep fakes and synthetic media, the use of personal information to mislead. So there's plenty more challenges. It's not going to go away for me. If you need help, use our website. We have a feature called Ask Us, which is a sort of semi-intelligent FAQs. Jump on there and chances are the question that you've got, somebody else has already had. And we've written answers to hundreds of them. If you ask a question that you don't find an answer to, we harvest those and write content for it. So the next person will get an answer. And it's really quite helpful for us in knowing what's going on, what's of interest out there. Like, I know you all like to record each other. Look at this, taping each other all the time. One thing that you can do today is jump onto our website and register for one or more of our online courses. We've developed these in conjunction with LearningWorks. So we bring the subject matter expertise, they bring the pedagogical, learning, educational expertise, and the combination means we've got some pretty good products there. Privacy ABCs are the real basics. So one useful thing is you could just go to this one here, Privacy ABC, email the link to everyone in your organization and say, guys, this is going to take you 20 minutes, do it. It'll just basically, you know, really a basic rising in the awareness. For a deeper dive, if you're the privacy officer in your organization or if you're the compliance manager or something like that, have a look at Privacy 101 and that'll take you through the Privacy Act. We will be soon making available a module which explains all the changes from the 1993 Privacy Act to the 2021. I told you about the new policy initiatives, which are the big ticket items, but there's a bunch of other sort of drafting matters and modernization of drafting and a few tweaks to some of the information privacy principles, which if you're into this stuff, you probably should know and familiarize yourself with. So do those, they're free. If you're a professional accountant or lawyer, you also get your CPD points for them. They've been very well received, and I have a list of all your names and email addresses, so I'm going to check that you've registered, so do it. And that is the cue for me to again point you to all our resources we're all over the social media and privacy.org.nz. I have some questions that have come in. I'm going to stop sharing my screen now, but you can get these slides from Jill, I think. We'll be sending those out, or Reese, I'm not sure. And how do you want to take this kōrero from here, Reese?
Well, thanks very much, John. I mean, fantastic walk through the new Privacy Act, and I think privacy is clearly topical in our industry and has been for a while, but also topical in New Zealand right now with some of the data breaches that you spoke about in the political sphere in the last week or two. So we have some questions, and we have some questions from your last session with us, which we didn't get time to address. So there's plenty of interest from our members in privacy. So I'll just go through some of those questions with you, and we'll see where we get to. So, I mean, I was very interested in, and I think we spoke about this last time, your idea of serious harm, but, and I think you provided some good examples of breaches that have led to harm at an organizational level, but I was quite keen, and I think some of the other speakers spoke about it last time as well, is obviously the Act is there to protect against serious harm. And I was wondering if you're able to share maybe some of the worst examples of where data breaches have been used to inflict serious harm more at an individual level on Kiwis, and that they're the type of acts that the Act is trying to protect against. Just to give a flavour of, you know, this is not just an act for an act's sake, this is actually there to provide protection to individuals and Kiwis.
Sure, thanks, Reese. And I think it's a really good point, because we sometimes lose sight of the human element when we're looking at these sort of big compliance legal questions. I mean, you know, let me tell you one example. There was a couple on a lifestyle block. They saw some dodgy behavior at a neighbor's place. They knew those neighbors weren't home. They saw a bit of activity. So they called the police. The police come around, catch guy, red-handed, put him in the back seat of the patrol car. The guy's been breaking into the house. The dispatcher is in touch with the police, and crackling over the car radio comes the, yes, we've had a call from Mr. and Mrs. X at Y address. They're reporting suspicious activity. So the guy's sitting in the car, he's hearing all this. So that's a disclosure of that information. Now he gets back to the station, he calls his girlfriend and says, and provides that information. She goes around to the house, throws a Molotov cocktail into the window, and the family flees with their 2 children, and the house burns to the ground with all their belongings in it. So yeah, it's hard to think about something more serious than that, but we have seen we've seen people being physically harmed, beaten. We've seen people just having to shift house. I had an example some years ago where a woman went to, she was referred to a hospital for a checkup in relation to her pregnancy, and the consultant saw her and wrote a letter back to her GP. Now the admission form had GP's name and address here and next of kin name and address here. The consultant wrote the letter saying, this is Mrs. So-and-so's 6th pregnancy. She's had 2 live births. She's had 2 terminations and 2 miscarriages or something. And instead of sending that to the GP, sent that to the next of kin, who was the woman's mother. And that caused very significant breakdown in that family relationship, and it was very, very hurtful. So, we see these physical harms, we see these very deep emotional harms. We see people who have, they lose trust and confidence. They can have very profound effects. on people. So you know, we are entrusted with this personal information. It's incumbent on us to treat it with great care and respect.
Yeah, thanks, John. I think the seriousness of some of those effects are probably beyond what I was imagining when I asked the question. So I think it does provide a great example of how even inadvertent data breaches can lead to quite serious harm, physical and mental, for individuals. So it's good to know that the Act is there to provide protections in those scenarios. And I think that segues on nicely to another question, which is understanding the harm that can be caused. We've seen some recent leaks of details of people infected with COVID-19. And you mentioned that MPs aren't subject to the same privacy requirements as private individuals. But let's say a breach of that nature occurred under the new Act, and it was by an organisation or a private individual rather than an MP. How would your office investigate and enforce in that scenario against a data breach of that nature?
We would investigate in the same way. We would still receive complaints. Again, in that scenario, the Minister of Health, who happens also to be the Minister of State Services, announced his own investigation, and that I think is appropriate. And if that was happening, we might let that run or work in conjunction with that. But there's no immediate sort of magic wand that I can wave. If I found some systemic non-compliance or some problem of that nature, I could issue a compliance notice if the agency declined to bring itself into conformity with my expectations of the law, and that they could then appeal that. So, and this is purely hypothetical. But say, for example, I were to look into that and find that the Ministry of Health's distribution of that identifiable information was not justified, I could serve a compliance notice on the Ministry of Health and say, you know, cease and desist sending these daily updates. You know, I could do it in terms of form. I could say sending a non-password protected spreadsheet is an accident waiting to happen. Don't do it anymore. It's not compliant. Or I could do it at first principle level and say there is no reason to send an Auckland helicopter rescue trust information about a Christchurch COVID sufferer who is in managed isolation. Stop doing that. So, you know, at the moment I can denounce, which I did do last week, and I can fulminate, but I can't do anything legally binding. I will be able to have some power to change those behaviours under the new Act.
Great. Well, it sounds like the new Act coming into force will be timely in the current circumstances. I think moving on to some questions from the last session and also from today, shifting the focus towards technology companies and our industry of technology and advertising. And I think we may have touched on this at the last session, but I do think it's an important question that's worth covering again for anyone that in this audience that wasn't there last time. So you talked about extraterritoriality under the new Act, and the question is, does that provision in the Act mean that the government can hold specifically the US technology companies accountable if data is breached from the cloud and if that data is stored in another geography like the United States?
Yes, it does. There's a couple of different angles here. One is that those companies, if they are doing business in New Zealand, are subject to the New Zealand Privacy Act and are therefore subject to that compliance notice regime. They're also subject to the obligation to report breaches. The other aspect, and there's a flavour that has come through several questions, I think, about your ability to use cloud services. Under the current Act, it's not considered a disclosure of information if you are giving information to an organisation for the sole purpose of processing it on your behalf. That is the intention is that that is carried into the new Act. So if you use Amazon in Singapore, a data center, or Microsoft Azure in Sydney, that won't be, that movement back and forth to those data centers will not be considered a disclosure to an agency outside New Zealand. That will be a processing purely on behalf. The restrictions on cross-border movement of data will only apply where that other agency is making a use of that information themselves. So there remains a question, for example, about Facebook and the extent to which it uses information which is carried on its platform. And so, that'll be an ongoing conversation.
Great, thank you. And look, I think that carries over quite nicely into a very short and simple question here from Aaron, which is, can we store data of New Zealanders in Amazon in Singapore? And it sounds like, from what you just said, that the ability to store data in other geographies is okay. Yeah,
I mean, you will be responsible for that security. So, you need to take, you need to do your due diligence and make sure that the service you use, whether it's onshore or offshore, has an adequate level of security to protect that information.
Fantastic. And there's a great question here. I think the New Zealand Privacy Act, and there's seems to be a lot of interest in how that relates to both US legislation and also European legislation. So the question here from Bogdan is, does the European Union legislation, GPDR, meet the minimum criteria for the movement of personal information from New Zealand according to the new Privacy Act?
Well, the answer's got to be yes, but I also have to go through a process of approving particular countries. But the GDPR is kind of the high watermark internationally for data protection. Yeah, I'm confident that when I come to assess countries that are GDPR compliant, I will also find that they have a comparable level of protection to New Zealand.
Thanks. And I think I did say GPDR and I meant to say GDPR. Another question from the last session was, will the changes to the Act place an obligation on website owners, presumably here in New Zealand, to disclose that they're collecting data in a similar way as Europe? So, for example, using a pop-up.
Well, we don't have the same cookie rules as Europe does. You'll know if you've ever visited a European website that there's a pop-up which requires that you sign, you signify that you've read their cookie policy and you accept it, and everybody signs it and nobody has. Yeah, I mean, there will be those transparency obligations on websites. They're there already. It's most important where there are unexpected uses of personal information. So, I'm not sure how big a problem that is, Reese, and whether I will be sort of going around online patrolling every website to make sure. Yeah, certainly there should be declarations of tracking activities and what personal information websites are collecting. There has also been a tweak in Principle 1 of the Privacy Act, which says that you should be able, where you can, you should be making services available without requiring people to provide their identifying information. So if you can provide information, if you can provide your services anonymously, then you should.
Okay, so you should only capture the data if you need to.
Yeah, exactly. Much better way of saying.
Thank you. And I guess there's a number of questions related to this. So there's an interesting angle in one of the questions from the last session, which was, I think we've established that it sounds like consent isn't mandatory when collecting information on a website, but what are the implications for storage duration for the data owner? I think you said the requirement is they should only store it for as long as they need to. So I guess that's how long is a piece of string. But if you could provide some examples on, sort of relatively common scenarios where you would expect people to be storing information from a website, what would be your sort of guidance there?
Well, again, it depends on your business need. I don't know about a website, but if you want to sort of common examples of storage periods, if an employee comes into your office and says, "I'm out of here," how long do you keep that last warning that you gave them, right? Well, you know that they've got 90 days to bring a personal grievance. And if they do, you want to have a proper record of your interactions to defend yourself. You know that under the Human Rights Act, a complaint can be brought within a year of discrimination. So again, that's one indication of a minimum period that you're not going to get any argument from me about, this is why I've retained this. You've got to keep those wage records under the Tax Acts for 7 years. So again, I'm not going to say you're breaching Principle 9 of the Privacy Act because you've kept my my income records for 5 years. And it's really up to your own policies and procedures.
Okay, so basically either follow other laws and acts or requirements to store information, or use, I suppose, reasonable judgment in terms of what is the period of time that you're actually required to hold and use this information.
Yeah. I mean, one thing that I did ask for in the new legislation, which we didn't get, is some kind of right to be forgotten or right to erasure, which is present in Europe and many other jurisdictions now, which would be an ability for someone to come to your company and say, look, I just don't want anything to do with your organization anymore. Please delete every record that you have of me. We don't have that, so people can't enforce that non-retention. It's open to you to say, well, you say that now, but I still might want to send you some, information about a great deal in a year's time. You're only harming your own brand if you annoy people by pestering them like that, but that's not a breach of the Act.
So annoying people and harming your own brand is not illegal yet?
No.
Great. So another question from the previous session, which I think is interesting, and again, it's back to this idea of how related is the New Zealand Act to what's happening in other markets like the US and Europe. And I think this speaks specifically to some marketing challenges which will be of interest to our members. So the marketers and agencies in the room are familiar with GDPR and CCPA, which broadly protect people from online ad tracking. Do your new powers enable you to look into this in New Zealand?
Well, yeah. I mean, if I felt that there was a business practice involving ad tracking that was non-compliant, I could serve a compliance notice on the organisation, either asking, requiring that they desist, or that they make their practices more transparent and explicit to users. Great.
And there's another question from Aaron here, which I think relates to this, which is what is classed as personally identifiable information under GDPR, which has classed IP addresses as personally identifiable information. So I guess the question there is, does the New Zealand Act apply a similar rule to IP addresses, or are they treated differently under the Act?
Well, it's entirely contextual. I'm not sure that if, we need to think of the application. It's not actually very helpful to say, is an IP address personal information? My answer to that is it can be. But if we take, for example, mandatory breach notification, if you have a printout of IP addresses and you lose it in the street, have you lost personal information? Maybe not, right? Because I can't identify an individual from that IP address. But when it appears connected to a string of searches or accounts, that will connect it to an individual and may mean that in that context that IP address is personally identifiable information.
So it needs to be related back to the individual. That's the key point. We're getting close to time here, but I did want to ask, I think, a question about, at the end of your presentation, you talked about preparing for the Privacy Act, which I think is obviously very helpful, again, for members as they think about the implications of the Act and what they need to do within their own businesses and organisations. And you mentioned that organisations should have a privacy officer, and if they don't, then they're already in breach of the current Act. I'm just curious, in terms of enforcement, so if there was a breach notification submitted, or there was someone made a case that there had been a breach, what would be the process of investigation from your office, and what would your office see as the absolute red flags in terms of if an organisation didn't have these things in place that would count severely against them, and then what steps should organisations take which may mitigate an outcome for them? So I think with getting more to the pointy end of implementation, what people can take away today to think about as they go back to their office, what are the things they should have, and what are the things that would definitely count against them if they didn't have them?
Yeah, I mean, as I say, there's been an obligation to have a privacy officer for 26 years. I don't know how many organisations don't. I've never done an audit, and I don't intend to go around knocking on everyone's door or hiring a call centre to ring organisations and say, who is your privacy officer? And then if they say, I don't know what you're talking about, send a compliance notice over. So again, we have a limited regulatory resource. I need to allocate that in a fairly thoughtful way to get maximum impact across the economy. So yeah, we will continue to see organisations ignorant of their obligations. For example, to have a privacy officer. Not having a privacy officer is probably not something that I'm going to rush to enforce. I will be making decisions about enforcement based on the seriousness of the apparent non-compliance, wider public interest concerns. Perhaps there'll be system issues. If I find that there is a sort of low level but widespread non-compliance in a particular sector, such as residential rental activities, I might invest some investigative resource and compliance resource there, and then publicise that, because there's an awful lot of landlords and property managers in the country. So we'll be trying to have a fairly strategic regulatory compliance approach, and getting the maximum impact for our very modest budget, which has to cover the entire economy.
Fantastic. And your office is prepared for the, I think you said you're expecting a 7% bump in notifications.
700%.
700%. Sorry, yes, 7 times bump in submissions once the Act goes into force. Are you resourced and ready to accept those submissions when the Act goes into force? I hope
so. Touch wood. We've built our reporting tool. We're trying to drive people to use that. We will be gearing up and taking on extra staff. I have got a bit of extra money in the budget to do that. So yeah, I'm hoping that we will.
Great. Well, John, we are almost at time here, so I wanted to thank you again for coming back and presenting to IAB New Zealand. I think the topic is of huge interest to our members, as I've said, and I think that's been reflected in the participation and the questions that were received, and I thank you very much for your time today and a couple of weeks ago, and also for taking the time to answer all these questions to the level of detail you have. So thank you very much, and that brings the end of the session.
Right, thank you, and thanks all for taking the time to inform yourselves about this. I appreciate it. Thanks to the IAB.
Thank you, John. Have a great day. Thanks, everybody.